Before the lunch adjournment, I'd refer to the last case that I intend to take your lordship to on Article 5.1c. That was Hassan.
Well, we probably looked at it over the adjournment.
Yes, I don't want to go back to it. I was saying I'd referred the court to
Right,
it. And
good, yes.
I now want to turn to...
And its importance is it just sort of, I mean, the facts are totally different. The importance, it just affirms what you've been saying all along, that there's a sort of consistent line of approach.
Yes, and it's yet another decision of the Grand
Chamber saying,
it's a Grand Chamber
how we do
decision.
it. Yeah.
Yes, and even when it's departing, it's very specific that it doesn't apply in this situation. So I want to now look very briefly to why it is the respondents' call for what we submit is a very significant departure from the interpretation, the consistent interpretation of Article 5.1c. I should make it clear that it is correct that we had not put our case on the basis that the detention was unlawful as a matter of domestic law. That is, that breach of the peace powers can never be exercised in domestic law to arrest an individual where there is no intention at the outset of bringing them before a court for a bind over, but where it's purely preventative. We didn't put our case on the basis it was unlawful in domestic law. So I shall proceed on the basis that domestic law does permit that.
Yes.
But our submission is that fact does not require this court in any sense to rewrite Article 5 jurisprudence, because a traditional reading of Article 5.1c, that is Article 5.1c read on the basis it is concerned with criminal proceedings, coupled with a reading of Article 5.1b, which mirrors the Ostendorf approach, amply provides for the circumstances in which the police need to or will need to exercise powers of detention in public order settings. So taking Article 5.1c for a moment, in many instances where a breach of the peace in a public order context is threatened, or even in a domestic context is threatened, most likely in a domestic context, there will be circumstances in which it is appropriate to contemplate the possibility of bind-over proceedings, and those will properly be contemplated by the police at the outset, because it will be either possible in relation to the particular individual or in relation to the circumstances to contemplate the possibility of a repetition. And then bind-over proceedings will necessarily be appropriate to be considered, and an arrest in those circumstances will fall within 5.1c. Then there will be circumstances where that won't be the case. That is, the circumstances really are ones where the detention can only be required on preventative grounds, because there is no possible threat of a repetition. And these sorts of circumstances arise in cases where what is threatened is a breach of the peace, most often not because of what the individual him or herself is intending to do. That is, the individual him or herself is not intending violence him or herself, because of course if they are, you can arrest them for an assault or a threatened assault, but where the breach of the peace is likely to arise because of the way in which the conduct of that individual is likely to arouse violence in others. And there will be a confrontation which is likely to turn into violence. That's the situation we were dealing with here. Now, in those circumstances, in our submission, Article 5.1b amply provides the means by which the police can deal with that kind of threat. Because in those kinds of situations, and they are arising, we are talking here about public order policing, we're talking about circumstances where the police are confronted with people who want to exercise their lawful and legitimate right to protest, to exercise their right to freedom of expression and freedom of assembly, but there is a risk, as there is in a football match situation, that they will come into confrontation with people who are antipathetic to them. And in those circumstances, the police can plan for that. They can plan for means by which legitimate protest can be facilitated without bringing those two groups into confrontation with one another. And the planning for that doesn't necessarily entail kettling them, but it can entail providing a place where they can exercise their legitimate means of protest away from the threat which gives rise to the imminent threat of the breach of the peace. And that doesn't necessarily entail hundreds of police officers surrounding them to keep them in place. It simply entails saying to them, we really accept you have a right to protest or a right to have your zombie picnic or whatever it is you were intending to do, but we'd like you to do it here rather than there. And then you don't need a huge number of police officers to make sure that they stay where they are. You don't need to confine them in the narrow confines of a heavily policed containment. But of course, that option is also there to the police. And the option of containment, in fact, is really the only option the police have in circumstances where there are large numbers of protesters who are and a serious threat of violence. Practically, where there are large numbers of people and a serious threat of violence, kettling and kettling alone is going to be able to address it. You cannot go around. The police resources will be insufficient in that situation to arrest everybody who is present. So all the police realistically can do in that situation is to kettle individuals and keep them apart from each other. And of course, kettling falls out with Article 5, and you don't need to give a warning. So there are 3 mechanisms there available to the police to deal with a public order situation. And in our submission, it is entirely possible for the police to plan for such circumstances and to give individuals a warning in such circumstances, which allows them to know what it is that is expected with them and to be given an opportunity to comply. And if things get out of hand, then they can be kettled or they can be arrested. So in our submission, there is no need for this rewriting of the convention. I've touched on this, but I do so very briefly again, that if Article 5.1c is to be rewritten in the way that the Court of Appeal has rewritten it, it doesn't produce greater clarity and sense. It actually produces a measure of absurdity which is not there either when Article 5.1c is read alone or when it's read in conjunction with the rest of Article 5, if the traditional, long-established interpretation is given. And what do I mean by that? The absurdity is this, that Article 5.1c lays out 3 grounds. It requires, in respect of each of those grounds, that the detention is for the purpose of bringing the person before the court and that they are, C5.3, entitled to a trial within a reasonable time. If the purpose of detention and the purpose of bringing them to the court is not referable to the bringing of criminal proceedings against them, but can be looked at as solely referable to the purpose of bringing them to the court for the lawfulness of detention on any one of those 3 grounds to be determined, then focusing on the 3rd ground, because it makes the point most starkly, one is left with a situation in which an individual can be detained to prevent them from fleeing following the commission of an offence, where there is never any need to try them for the commission of that offence, the fleeing from which, or from the trial of which their detention is intended to prevent. And you are simply detaining somebody for how long? For what purpose? Indefinitely, potentially, to prevent them from fleeing having committed a criminal offence. And that makes absolutely no sense of this provision. And on the Court of Appeal's construction, and the Court of Appeal neatly sidestepped this problem by simply ignoring the 3rd ground and saying it doesn't apply in our case, but on the Court of Appeal's construction, just as it is permissible to detain somebody to prevent them from committing a criminal offence as long as you intend to bring them to the court for the legality of that detention to be judicially determined, so too in relation to the 3rd ground. And that produces an absurdity that one simply cannot get away with. Whereas if, in fact, the purpose which is mentioned in Article 5.1c is recognised, as it should be, as being a separate and anterior purpose to the grounds of detention, then that problem simply doesn't arise. You detain somebody in relation to an investigation with the view to prosecution for a criminal offence on any one of those 3 grounds. And the whole thing becomes coherent, makes sense, and fits within the entire Article 5 framework. 5.1a is concerned with post-trial detention, 5.1c is concerned with pre-trial detention, 5.4 is the mechanism by which the legality of detention on any of the grounds in 5.1a to f can be determined. So in our submission, there is neither justification by reference to the needs of the police in relation to the exercise of their breach of the peace powers, nor is it a sensible rewriting such as should invite this court to consider departing. But we submit more than that. We submit it's simply not permissible for this court to depart on the basis of, I accept, it's not a codified set of rules that the court has laid down, but this court, the Supreme Court, has now given some very considerable guidance on the restricted circumstances in which it can depart from the clear and constant jurisprudence of the Strasbourg Court. And in our submission, those principles which have been repeatedly identified and refined simply do not avail or did not avail the Court of Appeal, and similarly would not avail this court in upholding the Court of Appeal's decision, which marks, in our submission, a very clear departure from that jurisprudence. Can I, just for speed, given how little time there is now, just take the court to the judgment of the Court of Appeal where the relevant principles are set out. They're not in dispute between the parties. And they're the court at MSP, so it's in the core volume, number 1, MSP 195, at paragraph 70, the court set out the circumstances, or began its analysis of the circumstances in which such a departure can be justified. And the starting point at paragraph 70 is the speech of Lord Bingham in Ulla, that the courts should, in the absence of some special circumstance, follow the constant jurisprudence of the court, the clear and constant jurisprudence. Lord Bingham said this reflected the fact that the Convention is an international instrument, the correct interpretation of which can be authoritatively expounded only by the Strasbourg Court. And of course, the starting point here is we are concerned very much with the interpretation of the Convention, of Article 5.1c's application and reach, nature and application, rather.
I mean, it's a very convenient summary at paragraph 80.
Paragraph 80 in my submission summarises the position in a way which we fully accept.
Yes, well,
So,
why don't we take it as read?
if we can just take that as read then, the question becomes, so the courts will be bound to follow an interpretation of a provision of the Convention if given by the Grand Chamber as authoritative, unless it is apparent that it has misunderstood or overlooked some significant feature of English law or practice, which properly explained would lead to the interpretation being reviewed by the court when its interpretation was being applied to English circumstances. The same principle and qualification applies to a clear and constant line of decisions of the European Court other than one of the Grand Chamber. And where there are mixed messages, we can see at 6, in the existing Strasbourg case law, a real judicial choice will have to be made about the scope and application of the relevant provision of the Convention. Now, mixed messages is mixed messages in the existing Strasbourg case law. Now, in my submission, that doesn't mean where you have dissenting voices or concurring voices setting out a different opinion, where those concurring voices themselves recognise that what they are saying is contrary to the constant case law of the court, and that is exactly what we have in the concurring voices to which reference was made this morning and to which my attention was directed. Those concurring voices started from the premise that we recognise that the court, in its constant, long-established case law, has taken a different line. We don't agree with it. Now, in my submission, that is not the kind of mixed messages that entitle this court to depart. The starting point is what is the clear and constant jurisprudence of the court. And in my submission, the sweep of cases that we've looked at this morning, which include a significant number of Grand Chambers as recently as Blockin, make the position of Strasbourg abundantly clear as to the application of Article 5.1c. The Ostendorf case...
Oh, sorry, did you say Blockin was a Grand Chamber case? It
Yes.
wasn't, was it?
Yes, it
So,
went,
yes,
Oh, well, yes, it was referred to the Grand Chamber. Quite right, yes, quite right.
but it's not really on this point. It's on
no, so
Which of the Grand Chamber cases you rely on?
So the Grand Chamber cases I rely on are Al Jeddah, A in the United Kingdom, Hassan, all three of which, in express terms, refer to Gethius, Chulla, and that line of authority, and say in terms that Article 5.1c is concerned with criminal proceedings, and most recently, Blockin. And Blockin, I accept, the issue before the court in Blockin was not Article 5.1c and whether the detention was justified under Article 5.1c, it was Article 5.1d. But nonetheless, the court took the opportunity to endorse the approach of the chamber, which had looked at Article 5.1c and which had also cited the Ostendorf case and its approach to Article 5.1c with approval. So we are simply not in the territory of mixed messages. We are in the territory of clear and constant jurisprudence. So the question then becomes, is there anything in English domestic law which could possibly cause this court to think that the Strasbourg court, if invited to do so, would revisit this long, long line of jurisprudence? And in my submission, the answer to that is clearly no. In Ostendorf, the position of the German government was far worse than that of the United Kingdom government because they simply could not bring this measure within Article 5.1c if the conventional interpretation was maintained, because breach of the peace there simply does not constitute a criminal offence. We're not in that situation. In many instances, an arrest will be lawful for the reasons I've given. And they refused. And we've seen all the arguments that were put forward by the German government are repeated by the police today. There's nothing more that can be said that would entice the court, persuade the court, and on which to revisit that jurisprudence. And in our submission, there is simply no basis to make such a departure. So we submit that the conventional meaning should stand, and it is taking on board what my Lord Mance says about, at the end of the day, what does it matter? What does it matter how we approach the detention in this question, if at the end of the day it is justifiable as being proportionate and not arbitrary? Does it matter whether it's under 5.1c or 5.1b? We do have a Court of Appeal decision that in our submission has departed profoundly from this long-established jurisprudence. And if it's done so, and it shouldn't have done so according to our own domestic law, then this court should say so and shouldn't let it stand. Otherwise, we end up being left with a decision of the Court of Appeal that is binding on all the courts in this country, below the Supreme Court, and it does have implications for example, judicial internment. And that is something which everybody, until now, until the Court of Appeal decision, had understood the Strasbourg court as setting its face very firmly against. There can be no judicial internment which is not connected to and does not arise out of criminal proceedings and the commission of a criminal offence.
The Court of Appeal clearly didn't have Blockin because that post-dated. I think I'm
Yes.
right about that. But what about the other Grand Chamber decisions that you rely on? Were they cited?
I believe they were cited, but I believe they were cited.
They're not.
Yes.
I don't think they're mentioned in the judgment.
They're not mentioned in the judgment, but I believe they were cited.
I don't remember Hassan.
No, Hassan wasn't.
A
No.
was and Al-Jeddah was.
Yeah, A and
I don't think
Al-Jeddah were
Hassan-
cited. Hassan wasn't because I don't think Hassan had been decided then. No, it hadn't been decided. So I'm sorry, yes, Hassan wasn't.
My Lord will see in paragraph 59 of the Court of Appeal's judgment reference to A and Al-Jeddah.
So, my lords, we do submit it. It is of importance, and this case, for the claimants, the case may concern damages. There is clearly a broader public interest in this litigation as to the correct interpretation of Article 5.1c and whether or not our courts are going to stay in train with Strasbourg or depart from Strasbourg. And so in our submission, the court should not turn its face against making a finding about the Court of Appeal's interpretation. Can I then turn to whether, as a matter of fact, the detention in this instance was for the purpose of taking the claimants before a court, and that is whether in connection with criminal proceedings, that is to seek a bind over, or to determine the legality of detention. And our position, as we made clear earlier, I think in response to questions by my Lord Toulson, was our position is that the purpose must be one which the arresting officer has at the time of arrest, and it must be a purpose which then governs the manner in which detention then unfolds and takes place. And so at the time of the arrest, it must have been in the contemplation of the person who was arresting to investigate whether or not to proceed with bind-over proceedings in order to prevent a future breach of the peace. And in our submission, a proper examination of the facts demonstrates that that wasn't the case, and I'll come to that in a moment, but we also submit that the Court of Appeal was wrong to infer, as it did, from the matters that it focused on, that one could establish such a purpose operating at the time of the offence, because the matters that the Court of Appeal focused on were the matter of law, which is that if you do detain an individual and by arrest in respect of breach of the peace, you have to bring them as a matter of law before a magistrate's court as soon as possible. And from that, coupled with this hypothetical circumstance, namely that things may have unfolded differently to the expectation at the time of arrest, such that they couldn't be released when it had been expected to release them, such that it would then have been necessary to comply with the legal obligations to take them before the Court, the Court of Appeal concluded you could then infer that that was the intention at the outset. Now, in our submission, that is simply not the case. One cannot make an inference from the fact that there is a collateral obligation to do something under the exercise or in respect of the powers that were exercised, but in fact those powers were exercised for that purpose, and that we are in a position to identify what the purpose was from the evidence in this case. And as I indicated earlier, that evidence shows that the arrests were directed centrally, officers on the ground were instructed to arrest, and that those arrests then took place not because of an assessment in relation to particular individuals or the risk that they presented of a future breach of the peace. They were then all taken to the police station, many of them were not even processed, and then a central command came again to let them all go because the celebrations were over. Not let them all go after you have decided whether or not they need to be processed in accordance with the reasons you initially arrested them, to see whether they should be bound over. So I'll come to that in one moment. Before I do, can I just deal with one other point? If we're wrong on Article 5.1c, if Article 5.1c is to be read as permitting purely preventative detention, as long as that is then judicially sanctioned, then there could never have been an intention to detain these individuals for that purpose, because the Magistrates' Court had no power to review the legality of their detention. The Magistrates' Court only had a power to determine whether or not they had breached the peace and to impose a bind over in circumstances where they concluded they had breached the peace. That's clear from Section 115 of the Magistrates' Court Act, and from the Justice of the Peace Act. You'll find those in Volume 3, tabs 15 and 16. I'm not going to take your lordships to it because we don't have time, but it's clear that the only powers they had were to make a determination as to their responsibility in relation to a past breach of the peace, and then to determine whether there should be a bind over. And then they could order their detention, but that was only in the event that the individuals refused to be bound over. And that is not detention to prevent a breach of the peace. That is detention to address the refusal to obey a court order. So, what are the matters?
Well, someone must have had power to act under Article 5(4) domestically. Who then was it?
Well, the magistrates could grant bail, but that is only where you're intending to pursue bind-over proceedings. But what they can't do is just deal with the matter on the basis that is your detention lawful to prevent a breach of the peace? Yes, if you wanted to review the legality of the detention that had taken place thus far, you'd have to bring a civil claim.
Yeah, I mean, you go for habeas corpus,
Yes.
or whatever the judicial
Yes, but
review.
the magistrates' court
No
couldn't do
problem
it.
under 5(4). There's no suggestion they couldn't get their case reviewed if there had been time to do it. But I mean, that's not the issue.
But the magistrates' court couldn't do it, so they couldn't be operating under 5(3). That's the point.
Yeah, I mean, I understand your point.
So there's no way that this would work within a 5(1)(c), 5(3) framework, even as understood by the Court of Appeal. So on the facts, what was the purpose of bringing them before the court? Can we just focus on the case of Mr. Hicks, because in our submission this best exemplifies the situation. This is all dealt with, all the factual arguments are dealt with in detail in the appellant's printed case at paragraphs 102 to 112 and in the appendix to the case. And that's at MSP 91 to 97. But if we can just look at the divisional court judgment at page 219 of the core bundle, at paragraphs 30 to 33, and that sets out the key facts in relation to Mr. Hicks. So his is the only case where he was actually recognised as a seasoned protester, long-standing involvement in Republican politics. We can see it, page 218, paragraph 30. Some previous convictions for minor offences committed when he was much younger, but no convictions over the previous 20 years. And then we can see that he wanted to go to Trafalgar Square because he knew that there was going to be a demonstration, and to Soho Square because there were also demonstrations, and to attend the Not the Royal Wedding street party organised in Red Lion Square. But he got as far as Charing Cross Road at 9 a.m. when he was stopped by a plainclothes officer who happened to recognise him. That was Police Inspector Paul Wakeford. Inspector Wakeford clearly knew him. Hello, Brian, he says. And he is then escorted, he's searched, street searches conducted, and we can see from Inspector Wakeford's statement that Inspector Wakeford was concerned that he was carrying articles that he might use to cause criminal damage, but I think he was found with a packet of biscuits on him. And then nothing else, and he was then arrested.
Do we need to go through all this? It's summarised in the statement of facts.
It's all there, but what I would submit is that it's worth looking at this because we can see it's worth looking at Inspector Wakeford's statement and the bits that are set out here.
What are we looking for
in the
then?
judgment?
You say it's worth looking, but what are we looking for?
For the fact that the direction to arrest both him and it's replicated in all the other cases came from a central command that wasn't looking at the particular circumstances of the individuals,
Yes.
and that the direction to release also came from a central command. That can be seen by the
But
notes.
I mean, I've got that point.
Yeah.
We don't need to go through lots of pages of stuff to find it.
Yeah, and in all instances, the direction to arrest and to release was prevented.
Where do we actually get in relation to Mr. Hicks that it came from a central demand? He appears to have come across a police officer who knew him.
So in 220, paragraph 12 of the statement of Inspector Wakeford, I spoke to Chief Inspector Dale and Commander Johnson over my mobile phone. We said it was necessary to arrest him now because if he got to Trafalgar Square and met up with others who were equipped to cause damage or harm, a breach of the peace would break out. And
Well, that's some evidence of planning, which it's good occasionally to hear happens.
it was the decision is to arrest him to prevent a breach of the peace. We then, and we can see in the other cases, and if I'll ask the court to look at them, that in all cases they spoke and were instructed to make an arrest. So, for example, Inspector Dixon, in relation to the Starbucks claimants at 596, and that's in volume 2.
Is it your argument that the convention requires the arresting officer to have a particular state of mind?
Yes.
Yes.
Well, why didn't he? I mean, looking at this, he's entitled to discuss it with others.
It strikes me as rather surprising if the Strasbourg court is laying down how police forces are to organise their operations. But it's not good enough to have a central direction of a police operation whose instructions are then carried out by officers, but that individual officers have to have a particular state of mind themselves.
Yeah, so the individual officer. So there's no reason why you can't have a central command saying arrest everybody and then investigate them all for a breach of the peace as to whether it's necessary to have a bind over. But the reality is, in circumstances like this, it will be absolutely clear that not everybody is going to be someone in relation to whom there are reasonable grounds to suspect that they might threaten a future breach of the peace. You've got people who are miles away, sitting in Starbucks cafe having a coffee at the time that this takes place. So insofar as one has a central direction, which all that direction and all that is discussed is arrest for breach of the peace, without any indication that there is to be a production of those individuals before the court and a processing and so forth. And we also have, in relation to...
common law, it's found that this was all lawful at common law. Isn't that a bit inconsistent with what you're now suggesting?
Yeah. Well, no, because I think I started, did I not, from this afternoon saying it was not our case. We have not. It wasn't our case that at common law you cannot arrest purely for on preventative grounds. That's what I started by saying this afternoon. So insofar as they arrested on purely preventative grounds, that may have been lawful at common law.
So just tell me, where are you in your case? What is the proposition we're looking at?
We're looking now at the evidence in our case.
No, where in your written case is the point we're now looking at?
Well, as I said, we are in our written case, we're looking at what was the purpose, as a matter of fact, of detention. So it's 102. As a matter of fact, what did they intend when they arrested? Because in relation to Mr. Hicks, on top of the discussion at the time of his arrest, he then gets to the police station, and it is then made clear that the expectation is that he is going to be held only, and we can see this at MSP 648, which is in volume 2, his custody record. We can see he gets to the station, 10:55, page 648, 10:55, that top paragraph, it explains how he's brought to the station, and then in the third paragraph in that top box, I explained that to PD that as he was in custody to prevent a breach of the peace, he was unlikely to be released until the celebrations had finished. After speaking to Bronze Crime earlier, Bronze Crime being one of the commanders, this is anticipated to be at 3 a.m. I think that's a mistake, the 3 a.m.
No,
it's not a mistake. Okay, 3 a.m. I relayed this to PD, and he made no representations. He appears resigned to his fate. And then we get at 2:34, at the bottom of page 649, I've just received information from DS Annette Maslin, who's from Op Malone Bronze Crime Support, again, relayed from Central Command. As the wedding itself is now over and the associated immediate celebrations have finished, there is no longer a likelihood of a breach of the peace, and PD may be released. Not PD should now be processed to see whether or not a bind over is appropriate.
We've got it, if we really need to get into this, we've got his own witness statement, MS 556, where he says in terms, at 9:10 a.m. I told Mr. Hicks I was arresting him under common law to prevent a breach of the peace, and I believed he would be involved in the breach of the peace in the immediate future, and that harm would be done to which he'd be a party or would be involved in. I stated he would be detained for as long a period as was necessary until such threat of harm had passed, but he returned to a police station. He replied, last time I got £4,000 for a breach of peace arrest, so I don't mind.
Yeah. So paragraph 16 is the key paragraph there. And in our submission, it makes clear.
Can I just ask, in the context of the court's judgments below, this is a new point, is it? You're asking us to make findings because the courts below, on the interpretation they adopted, didn't need to make them. Is that right?
Yes, so the divisional court didn't itself make a finding as to the...
Whether there was, whether if you're right under Article 5.1c, there was the 5.1c purpose which you contend for. So you'd be asking us to infer from the
material.
From the material available.
Because the material available, this was a judicial review, so the material available constitutes the totality of the evidence, and that issue was a live issue at the beginning of the proceeding.
They haven't got any findings on it in the courts below at all.
No, so the divisional court made no finding because the divisional court's approach was lawless is wrong, and therefore there need not be any intention to bring the individual before the court.
I suppose there might have been, if people... Is it possible that, as the Court of Appeal, I think, was suggesting that there might have been further evidence if people had appreciated what the law in Strasbourg might be?
Well, the law in Strasbourg was clear.
No, but you say they got it wrong, and supposing they'd have got it right below, might they have admitted or looked for further evidence or not?
But what I mean by that is the case was prepared at a time when, albeit it was argued by the Metropolitan Police Force that lawless should be departed from, lawless stood at that time until the divisional court made its determination, and therefore the case had to be prepared on the basis that they had to establish an intention to bring before the court. So in my submission, there isn't any room for saying in relation to this issue that further evidence would have been prepared.
Well, what the Court of Appeal did make a finding, didn't they? And they had the evidence of Hicks that we've just been looking at, that he was going to be detained for such period as was necessary until the risk of breach of harm passed. Court of Appeal, paragraph 85 of their judgment, said that the police officers must have realised it wouldn't be possible to prolong the detention for very long without taking the appellants before the magistrate's court.
Yes, and
now you say that as a matter of fact it was not open to the Court of Appeal to conclude that that must have been appreciated by the police officers.
In my submission, the fact that it was appreciated by the police officers, let's assume it was appreciated by the police officers.
Right.
My submission is it doesn't entitle one to
Right.
infer from that fact, that obligation, that in fact it was their intention to do that.
Well, I mean, it's a very fine distinction, isn't it, between saying you can't challenge the inference that they realised they would have to be taken before the court within a reasonable time, but that wasn't their purpose. It was foreseen as something they would do, but not part of their purpose. That's the distinction which you draw.
We submit it's a very important distinction because the purpose must be to bring criminal proceedings. The fact that they are aware that as a matter of law they have to bring somebody to the magistrate's court does not mean that when they arrested it was their purpose to actually invoke those criminal proceedings. Because if we're right and the facts do demonstrate what we submit, which is that there never was any intention, that legal duty was still there. It doesn't go away, but this power was not being used to bring them before the court for the purpose of criminal proceedings. It was a power that was actually being used for an ulterior purpose, namely preventative detention. So in our submission, firstly, one can't infer that from the legal obligation, and secondly, one can look at the evidence in this case, and that evidence is sufficient to demonstrate that actually the purpose was clear. It was a clear preventative purpose. They wanted them out of the way for the course of the wedding celebrations. Once that was over, then they were going to be let go. And it was a mass instruction to arrest anybody found anywhere in who it was believed was wanting to head into the celebrations and demonstrate in whatever way they were choosing to demonstrate. And it was
Yeah,
a
so
massive-
you draw a distinction between intention and purpose.
there is an important distinction between the arrest being for the specific purpose of instituting criminal
Yeah,
proceedings.
but as I say, you draw a distinction between intention and purpose because you say it's not enough that they intended to bring them before court within a reasonable time. It has to be their purpose to bring them before court.
No, it has to be the purpose for them to institute criminal proceedings. So the fact that they knew
Even,
they
even,
had
if
to,
even if there are no criminal proceedings to be instituted.
yes, exactly. So if if in fact they were only ever arrested for preventative purposes, then had they not been allowed to release them because the disruption and so forth was still ongoing, they would have had to have brought them before a magistrate's court, but they wouldn't have been doing so for the purpose of then saying, please bind these people over. They would not, they would have had to bring them before the magistrate's court, but that would not have been their purpose. They would then have been in a bit of a pickle, really, wouldn't they? They would have then said, well, we've got to bring them before you, but actually we're just holding them preventatively. We don't want to bind these people over because we don't think they're a threat. They constitute a threat. And that's why one has to focus on what was their specific actual purpose, and you can't infer that from the fact they're exercising a power which creates a particular legal obligation. Because the question is, are they exercising that power for that purpose? And the answer in our submission is no, they're not. So that then is 5.1c, and the factual side of 5.1c. I still have to deal with 5.1b, and I don't think I'm going to have to take very long, but I noticed that my time is up, but the court did start a little bit later this morning, and have I got another few minutes? I think Mr. Grzyński said to me yesterday he didn't think he was going to be his full 2 3/4 hours. I'm not going to be long on 5.1b because I've covered a lot of the territory.
You need to deal with it, but pretty quickly. I think we didn't start that late.
I will deal with it pretty quickly. So 5.1b, you've indicated to me that you've read the Ostendorf decision. Ostendorf, in our submission, sets out the clear and constant jurisprudence of the court on 5.1b. At paragraph 69 to 70, it cites a number of cases.
It comes down to a very short point as to what warning, if any, they need to give. That's the difference between you.
Yes, I think
and
the
the
question
one
is,
sentence in Ostendorf which suggests you need a specific warning, and they say that's not
yes.
General application.
Yes, so their position is you don't need to give a warning. Our position is you do.
Well, they say in a situation like this, where there was only one practical thing you could do, you don't need to give a specific warning,
yeah.
because everyone knew what was going on anyway.
Has anybody ever considered, in the context of 5.1b, the public law duty of the police?
Law duty?
Of the police.
Yes.
The public law duty of the police,
police,
to...
Well, I mean, there's authority going back centuries that
Yeah, I mean,
but the duty of the police is to prevent a breach of
prevent
peace. And if the only way to secure the fulfilment of that breach, that obligation to prevent a breach of the peace, is to arrest somebody or detain somebody, has anybody ever given consideration to whether that falls within Article 5.1b?
Well, I mean, it has been considered, and the court has considered the general duties on the part of the police to prevent crime or to prevent a breach of the peace, and that's been part of the jurisprudence running right back from England, the Netherlands, where the court has said...
but I think it's more specific. What my Lord is saying is that in B, when it refers to securing the fulfilment of any obligation prescribed by law, the obligation in question could be the obligation of the police, not the obligation of your clients. I mean, it's to me a completely new way of putting it, but it would fit the wording of the provision. I think that's right, isn't it?
Yes. Has it ever been addressed?
So the obligation of the police
To
prevent...
preserve, exactly, to
Yes.
protect. I mean, you're going back for centuries. The primary obligation of the police is to preserve the Queen's peace.
Yes, but the detention is what Article 5.1b is concerned
And
with.
if the only way of fulfilling the obligation to preserve the peace is to detain somebody, question, has anybody considered whether that is authorised under Article 5.1b? Maybe it's never been considered.
May I just clarify for a moment?
Have a look at 5.1b. I mean, it came as a bit of a surprise to me. So, in order to secure the fulfilment of any obligation prescribed by law, it doesn't say whose obligation it's got to be. My Lord is putting to you that the obligation in question might be the obligation of the police to preserve order.
Yes, but then the detention, it's the detention which must then... Well, there are two answers to that. Firstly, the court has repeatedly said that the obligation must be a specific and concrete obligation. So a general obligation to prevent a breach of the peace is insufficient. It's too general, it's not sufficiently concrete and specific. And therefore, that's...
That's looking at the obligation of the citizen who's being arrested. I don't think any of these cases have looked at the thought that it might be the police's obligation, which is sufficient.
In a specific situation, not just a general obligation to preserve the peace, but the specific obligation of the police to preserve the peace in this particular situation with which the police officer is confronted.
Well,
if he is under that public law obligation, does Article 5.1b permit him to do so?
Well, in my submission, Article 5.1b only permits him to do so in precisely the same circumstances in which Article 5.1b permits him to detain to prevent a breach of the peace where the focus is on the person who is threatening the breach.
So do you say that any obligation is to be construed as any obligation of the person being detained?
Yes. I mean,
but then that doesn't fit with your argument that the person being detained might actually not be the person who's threatening, but might be the person who is potentially going to be threatened.
Yes. So
it can't, on your own construction, be limited to the person who is a threatening breach, can it?
No, because if one deals with a situation, if one has a situation where there is a threatened breach of peace, and the person whose detention is sought is not themselves going to breach the peace by any violence on their part, but their presence is going to provoke others into violence, for example. In that situation, you could impose upon them an obligation, a very concrete and specific obligation intended to prevent a specific breach of the peace, such as not to stop, don't go further forward to wherever it is that the individuals are who are antagonistic are positioned. And there, the obligation in question, the concrete and specific obligation, the aim of which is to prevent a breach of the peace, is the obligation on that individual not to go there. That renders the obligation to prevent a general obligation to prevent a breach of the peace sufficiently specific and concrete for Article 5.1b purposes, because one of the conditions is that it must be a specific and concrete obligation, not a general obligation not to breach the peace or not to commit a crime. So it does both. It fulfills both that purpose, but it also identifies an obligation that the person, whether innocent or not, in relation to that threat, must comply with.
So if a police officer says to an innocent person who's a potential victim, stay here, that creates an obligation prescribed by law.
Yes, because if it's a lawful order of the police officer, that creates an obligation. If the officer, it is, as a matter of common law, police are able to impose directions against both the innocent and the potentially guilty.
So prescribed by law means no more than lawful.
Yes, so it'll be a lawful order made by a police officer which identifies with specificity and concreteness the nature of the obligation in question, the fulfilment of which will prevent the breach of the peace.
Right. Anyway, I'm conscious you haven't got much time. I just wanted to know whether the question which I asked had ever been addressed by a court.
Well, my answer to that is I cannot think of any authority where it has been considered from the point of view of the police, as opposed to the obligation in question being one which is imposed by the police upon a particular individual.
Why, if somebody is committing a breach of the peace and you're not interested in arresting him and prosecuting him, you just want to stop him, do you have to come up to him and say, please desist, and why is it you're only entitled to detain him under B if he fails to comply with that request? Can't you stop the breach of the peace before it goes further? You have to allow it to go on.
In my submission, well, you're not allowing it to go on. If you come up to somebody and say stop, in fact, you actually, if you come up and say
You're not
stop,
allowed
you're
to
acting more quickly than you do if you arrest somebody. And as we see in all these cases, what do the police do? In all these cases, they go along and they say, stop what you're doing, and if you don't, I'm going to arrest you. And it's to simply verbalise a command is a far quicker way, if it works, of achieving somebody's the end of a threatened breach of the peace. If it doesn't work, you immediately set about arresting them. But what you do by saying to them, stop what you're doing, is you give them a specific command and obligation which renders concrete what it is they have to do in order not to breach the peace. So if you're far away from a situation...
It's no good saying it's perfectly obvious what you're about to do, and we're going to take you into custody. You've got to say it's perfectly obvious what you're about to do. Now you must please... assure me you're not going to do it, and then I'll walk away.
A request to assure me you're not going to do it is not an obligation. It's not the imposition. You have got to either, I'm very sorry, but I know you want to go and celebrate and have a demonstration, have a picnic, a zombie picnic in whatever square it is, but we are concerned that there are people who are antagonistic to you, don't want you to be there. We're concerned it's going to create a breach of the peace. Please, you're not to go there. What you can do is you can accompany us, and there is an area where you can demonstrate, or what you can do is you can stay in the cafe in Starbucks for the duration of the celebrations, but you are not to go there. There are a number of alternatives, and this is what they do in football matches all the time. They don't go about arresting everybody who they think is going to threaten a breach of the police at a football match. They issue instructions and orders and have public policing methods and sufficient numbers of police officers to deal with it.
Yeah. Right.
I must say, I thought this part of the case was not controversial. I may be wrong, but I thought that it was accepted in the respondent's written case. That save in cases of urgency, immediate necessity, and so on, that there was a duty to make a specific and concrete.
And the defendants argue this was a case of urgency and immediate
they
necessity.
say that it falls within the exception. I thought that was the ambit of the difference between you.
But our submission is that where it comes to a breach of the peace, the need, so the case law is very, very clear. If we go back to Engels, that it is not good enough simply for there to be a general obligation to prevent a breach of the peace or to prevent crime. It has to be made specific and concrete, and the obligation has to be made specific and concrete to the individual. And we can see that through Schwaber.
Yes, well,
and that is why...
I mean, Engel is distinguished between a case where you're just detaining in order to secure the general duty of obedience to the law,
yes,
and the case where you're detaining in order to compel the fulfilment of a specific and concrete obligation. Doesn't much help you as to the dividing line.
No, but then we get more help, specifically in relation to the context of something like a breach of the peace.
It's really Schwaber.
In Schwaber.
Yeah.
And there it's at 2:12.
Yeah. MS 1802, isn't it?
That's right. And the relevant paragraph is
82.
And this tells you why, in the context of prevention of breach of the peace, you actually need to make it concrete and specific by giving some sort of order. So it's not simply that the order is necessary. You must give the order in order for somebody to, for the obligation to have been antecedent and that they must have shown an unwillingness to comply. It is also necessary to give an order or a direction as to what an individual should or shouldn't do in order to make the obligation sufficiently concrete and specific.
Well, I think we've got the point now. Is that it?
So that is why, even if this court were entitled to say, well, McVeigh was a commission decision in which the court held that in certain circumstances of immediate necessity it's not necessary to give a warning, we would submit that in a case such as this, where one is dealing specifically with obligations which are imposed to prevent a breach of the peace or to prevent crime, it is necessary to give a warning or to specify what the obligation is, to bring it in the first limb of Article 5.1b, which is the need for the obligation to be sufficiently specific and concrete in respect of the prevention of crime or the breach of the peace. So our primary submission is McVeigh is an old decision of the Commission, and it hasn't found itself into the Strasbourg Court's subsequent authorities, hasn't informed the way that Strasbourg has approached this issue since, and that Schwaber and Ostendorf are entirely consistent with a clear and constant line of jurisprudence, and that there is no need to depart from that. And just on the facts...
I think you really ought to wrap up your submissions very quickly.
Can I simply then, for your Lordship's pen, ask your Lordships to look in your own time at Superintendent Morgan's tactical plan. That's in Appendix 2, and at page MSP 524 and 52728, your Lordships will see the planning that was made for an opportunity to be given to individuals to continue their activities, whether they be protest activities or simply having a picnic, in Soho Square. And we do submit then, finally, that while the Court of Appeal made no findings on whether or not an order was given that rendered the obligation sufficiently specific and concrete, it's clear from the evidence, it's never been asserted that any such order was given, it's clear from the evidence that a decision was made to arrest, and then an arrest was effected without any orders being given, that the claimants desist from any particular activity or engage in any particular activity. So, my Lords, unless I can be of any further assistance, those are our submissions.
Thank you very much. Indeed, Ms. Brander. Ms. Grudziński.
I hope it would be helpful if I start by defining what we say the scope of the issue is in this appeal. The Divisional Court has found that the appellant's arrests and detentions were, in each case, effected to prevent an imminent breach of the peace and were lawful at common law. As I said earlier, permission to appeal to the Court of Appeal was refused on that ground. And at the highest level of generality, therefore, the issue before you is whether, nonetheless, the appellant's short detention was unlawful under Article 5, being neither authorised by Article 5.1c nor 5.1b. And just dealing with each of those paragraphs in turn, as to 5.1c, although there is an interesting debate about whether the court's reasoning in Ostendorf is correct, and I'll engage with that debate properly in due course, ultimately the answer to it does not, on my learned friend's case, determine the outcome of this appeal. My learned friend concedes, as she has to given the decision of the court in Steele, that if the police had the relevant purpose of bringing the appellants before the magistrate's court for a bind-over hearing, Article 5.1c is satisfied. That is because, although breach of the peace is not an offence as a matter of domestic law, it is an offence for Article 5 purposes, and a bind-over hearing requires the magistrate to decide, to the criminal standard of proof, whether there has, in the past, already been a breach of the peace, that being a necessary precondition of imposing a prospective binding over order. So put in the language of my learned friend's case, a bind-over hearing constitutes a criminal trial on the merits because breach of the peace for Article 5 purposes is a criminal offence.
But by breach of the peace, do you include threatened breach of the peace?
Yes, because as a matter of domestic law, the two are equated.
Yes.
So the ultimate scope of the dispute under 5.1c is extremely narrow. It is whether on the facts the police had the necessary contingent purpose of bringing the appellants before the magistrates in the sense explained in the Brogan case. And the Court of Appeal at paragraphs 85 and 86 found that such an intention was present, and I will make my submissions in due course as to why they were right to do so. And the question from my lords ultimately is whether you interfere with that finding made by the Court of Appeal. That's the ultimate determinant of the appeal under Article 5.1c.
Did they find at 85 and 86 that there was an intention to do more than bring them before a magistrate's court?
Yes, but if they had the intention to bring them before a magistrate's court on a bind-over hearing, and if, as my learned friend concedes, a bind-over hearing constitutes a criminal trial, then on her case, Article 5.1c applies.
So you say that if there was the intention to bring them before a magistrate at all, it must have been
For a bind-over.
for a bind-over.
There's nothing else.
Yes, but you've inserted the word contingent, and I'm not sure that Ms. Kaufmann is accepting that an intention to bring them before the magistrate's court in the event of certain contingencies
I accept.
would suffice.
My lord is right that there is a dispute between us about what Brogan requires and whether, if at the time somebody is arrested, the police have in contemplation the possibility of a bind-over, if events transpire so as to require it, that is enough. She says, no, they must have a fixed intention at the very moment of arrest and at all material times thereafter, always to bring somebody before a magistrate. And we're going to have to get into what Brogan really requires. So there is a jurisprudential debate about what Brogan requires, but ultimately that is what the appeal under Article 5.1c boils down to. On Article 5.1b, the scope of the dispute is again narrow. It is as follows. It is whether the arrest and detention is only lawful under 5.1b if, prior to the arrest, the police give a warning that the individual will be arrested if he or she fails to comply with some specific instruction to do something or not to do something, and moreover, that this rule applies even where, as the divisional court found on the facts in this case in a passage that I'm about to take you to that you haven't seen yet, that such a warning would not have been a realistic means of preventing the imminent breach of the peace.
I'm sorry, sir, just going back a moment. Is it right that if the police had brought Mr. Hicks before the court, it could only have been to seek a bind-over order?
Before the magistrate's court,
Yes.
there might have been a range of other criminal offences for which he might have been brought, but that isn't...
But I thought that magistrates do have a certain jurisdiction to allow a period of detention to be continued while the police are conducting inquiries.
But they do, my lord, but that isn't the fact of this case.
No, but you're saying that, well, I mean, if they'd been in the position that the situation had dragged on for a good number of hours,
Yes.
and the police had said we need to get authorisation from the magistrates, would the magistrates have had jurisdiction to say, yes, well, in view of the circumstances raging, you may continue to keep them in on grounds that you have, without us determining whether a bind-over order should be made?
No.
They don't have that power, would they?
No. What the magistrates have the power...
What's the authority on that?
I'll take you to it in a moment, but
Okay.
ultimately, the authority for what they can do is Section 115 of the 1980 Act and the authorities that explain what that involves. So if, to take a hypothetical example that I'll come back to, any of the appellants, having been arrested and detained for 3 or 4 hours, the situation in central London had deteriorated, or if the celebrations had lasted into the next day, such that the police considered that if they were released, the same risk of breach of the peace as they had arrested them for would continue, and therefore it was not appropriate to release them. They would have had an obligation at the earliest possible opportunity to bring the appellants before the magistrate court whenever it next opened. At that moment, the appellants would have been brought before the court, and the court would have examined 2 things. First, whether there had been an imminent breach of the peace in the past, i.e. the threat of violence or the imminent threat of violence. And secondly, whether there was a risk that if not bound over, the individual might repeat that conduct. If they were satisfied of both of those limbs to the criminal standard of proof, what they could require the appellant to do was be bound over with or without sureties, i.e. promised, in old parlance, to be of good behaviour. If the appellant refused to do that, as, for example, the appellants did or the applicants did in steel and nickel, then they could have been imprisoned. That was the power open to the magistrates' court. I hope that answers my Lord's question.
Right. And that's all to be found in the 1980 Act?
Well, that's to be found in the 1980 Act and in the case law to which I'll come shortly. My Lord, with that introduction to the scope of the appeal, can we just look at a number of the factual passages in the divisional court's judgment, not least because, as my Lords all well know, Strasbourg is acutely fact-sensitive when drawing its conclusions. Just to pick up paragraph 4 of the divisional court's judgment, it's important to recall the scope of the various issues that were before the divisional court. Various grounds of challenge were advanced, and you can see that from page 4. I beg your pardon, paragraph 4. The first was that the police had operated an unlawful policy or practice of preemptively arresting people like the appellants who were thought by the officers to be likely to express anti-monarchist views without proper regard for lawful preconditions of the arrest, and/or operated an impermissibly low tolerance of threshold for public protest. That ground of challenge was dismissed. Secondly, that the arresting officers did not apprehend an imminent breach of the peace, and/or there were no reasonable grounds for so apprehending. And although at times my then friend Miss Kaufman's submissions to this court, particularly in relation to the Starbucks appellants, appeared inferentially to suggest that there was no such imminent breach of the peace, on the facts and the evidence exhaustively analysed by the divisional court, and from which there has been no appeal, there was found to be an imminent breach of the peace, reasonably apprehended on the evidence before the officers. Third, that the decisions to arrest the claimants were wholly disproportionate, and the court's findings as to that proportionality complaint are directly relevant to the Article 5 complaint for the reasons I'll come back to in a minute. Fourth, there was an O'Hara unlawful fettering of discretion argument, also dismissed. And 5 were a variety of convention grounds, of which only, of course, Article 5 has survived. Can I take you to paragraphs 11 and 12 then, and just invite you to read those 2 paragraphs to give some important context to the situation with which the police were dealing at the time, because that context is directly relevant to Miss Kaufman's submission about what the police could and could not have done by way of planning. My Lords will see at the end of paragraph 12 the kinds of conduct about which there was reasonable fear on the basis of the intelligence that the police had, including, and I'll come back to the relevance of this, throwing maggots at those celebrating or participating in the royal wedding. And that's directly relevant to the zombie claimant's fact, as we'll see in a moment. Then we turn to paragraph 24, which recites the fact contained in Sub-Bronze Commander's tactical plan. And you can pick it up from the last sentence in the main paragraph, which says that one of the geographic areas referred to in the plan was Soho Square, in relation to which the following was added the day before the royal wedding. It's come to light that intelligence currently exists that some protest groups intent on disruption intend to meet in Soho Square at 10 o'clock, engage in protest, and then march to the ceremonial area via Piccadilly. Police will facilitate peaceful protest and will work with organisers and participants to ensure that this occurs. However, given the events of the day, and in accordance with Gold strategy, such groups intent upon disorder will not be allowed to process towards the ceremonial area for the following reasons. And then my Lords will see 3 indented passages, all of which are applied. Then we see at paragraph 25 reference to the increasing level of intelligence that Commander Broadhurst, the Gold Commander, was receiving in the immediate lead up to the wedding. And halfway through paragraph 25, you see the sentence starting towards the end of the line. The TUC march on the 26th of March 2011 marked a turning point. It attracted a relatively small but significant number of activists intent on using it to further their own cause, which led to violence and serious damage. Following this, it became clear that the policing operation would need substantially to be increased. And then there's a reference to Commander Johnson's intelligence. And in the indented passage, you can see, 4th line down, at this time there were numerous non-specific events being mooted over the internet, with a couple of events, namely the Right Royal Orgy or Zombie Wedding, and an anti-wedding event in Red Lion Square. As the actual aims of these were unknown, this is obviously relevant to the planning suggestion made by my learned friend, and with no recognisable organiser, it was impossible to interpret whether they were going to be peaceful. However, some of the phraseology used seemed to suggest there would be activity aimed at disrupting the event, such as sit-down in roads, occupation of buildings, climbing onto roofs, smashing up of shop windows, for example, in the West End. One of the leaflets referred to throwing maggots at the royal procession. And then, if I invite you to read all of paragraph 27, which expands upon that. My Lords, I don't want to take up too much time, so can I give you some paragraph references next to address Miss Kaufmann's inferential assertion that there was really no imminent breach of the peace. That assertion failed in the divisional court, and the relevant passages in which the court dealt with it can be found at paragraphs 158 all the way through to 170, and I'm not going to repeat them. But then what I am going to focus upon is paragraph 171 and 172, which dealt with the further argument, very similar, in fact, in substance identical to that advanced by Miss Kaufmann now, concerning alternative measures short of arrest that could have been used by the police. You see the nature of the contention in the first few lines. It was submitted that even if a breach of the peace was reasonably apprehended to be imminent, the police were required to take no more intrusive action than was necessary to prevent such a breach, and that the onus is on the party taking the coercive action to show that what was done was no more than necessary. In all the authorities considered in the House of Lords decision in Laporte, in which coercive action for breach of the peace was upheld, less coercive measures were attempted first, and it was only when such measures failed that a greater level of coercion was justified. In this case, on the information known to the officers, there were alternatives. And then it's critical to see what was being suggested could have been done. The claimants could have been asked to go back or remain where they were, or could have been accompanied to locations where the expression of Republican views wasn't deemed to be likely to cause a breach of the peace, or they could have been monitored. If their appearance was considered to be a source of potential provocation, they could have been asked to change it, for example, by removing zombie makeup. If the flyer in the possession of the second zombie claimant was considered provocative, she could have been asked to hand it over. These were claimants of generally good character, and it can't be right for the police to have assumed that they would not accept a warning, instruction, or request. The claimant's submissions on this issue appear to us to be wholly unrealistic. If, as we have held, there were reasonable grounds for believing in each case that a breach was imminent, it would have been plainly inappropriate in the particular circumstances for the officers simply to issue a warning or to request or instruct the claimants to go back or stay where they were or move to another location. Without constant police supervision, it would have been all too easy for them to carry on with their intended actions. Nor, as Ms. Kaufman still suggests in this court, was constant police supervision a realistic option given the many demands on resources on the day. Similarly, to have asked the Starbucks claimants to change their clothing or remove their makeup wouldn't have dealt with the underlying concern about their intended actions, nor would have precluded their reverting to their appearance once the police had left, etc., etc. My Lord, permission to appeal was sought on that ground and was refused. And for your Lordship's reference, the refusal of Appendix 3 permission can be found in Appendix Part 3, MS 1223, and I'd invite you to turn it up. This is the order on the papers made by Lord Justice Lloyd Jones. Ground 1 was the policy ground, dismissed, and the imminence ground. Ground 3, most importantly, is that the submission that there might have been some equally effective but less intrusive response is, in the factual context, totally unrealistic for the reasons given by the divisional court. Ground 4 was the Article 5 ground, and permission was refused. There was then an oral hearing in front of Lord Justice Moses, in which permission, you can see that from the next page, 1225, and you can see in the bottom third of that page, having heard leading counsel for both sides, permission to appeal was refused on all grounds other than the Article 5 ground. So, my lords, in our respectful submission, this appeal, i.e. to this court, can only proceed on the factual basis that a warning requiring the claimants to do something, move to another location, change their appearance, hand over a flyer, etc., and then be monitored for compliance with that warning as a precondition to their arrest, would have been a wholly unrealistic means of averting the anticipated breach of the peace.
So we should effectively just recite that, and if Strasbourg is invoked and takes a different view of the facts, that's writ.
Well, my lord, Strasbourg is, as my lord knows, very slow indeed to take a different view of the facts from the domestic courts. It sometimes does that, but very rarely.
Yes. Depends whether they're prepared to act as a further court of appeal.
Yes. Can I now deal briefly, before turning to the Strasbourg case law, to the protections contained in the common law before a person can be arrested and detained to prevent a breach of the peace. And they are most conveniently found in the House of Lords decision in Laporte, a Authorities Bundle, Volume 1, Tab 2.
Can you just explain what the relevance of all this is?
The relevance is that in our submission, since my learned friend's case is that there is some structural difference between the requirements in the common law before a breach of the peace can be lawful, as it has found to be in this case, and the requirements of Article 5, it is relevant to see quite how extensive are the protections already inherent in the common law, which the divisional court has found were met on the facts of this case. It'll take no more than 5 minutes. So the first of the three critical protections is that breach of the peace as a concept involves violence or the threat of violence. And again, Ms. Kaufman kept on talking about people sitting in Starbucks as if this was a wholly innocent activity and there were no reasonable grounds for apprehending a breach of the peace. And a breach of the peace is violent or intended violence. And we can see that from Lord Bingham's speech, paragraph 27, MS 1367. So that's the first of the three requirements before somebody can be arrested to prevent a breach of the peace. Laporte, as a matter of common law, is the leading House of Lords authority on breach of the peace. And we'll see strong similarities between the analysis of the House of Lords in this case and the earlier analysis of the Strasbourg Court in Steele. So paragraph 27, Lord Bingham refers back to the Court of Appeal's decision in the case of Errol Howell, and Lord Bingham summarises it in the last sentence before the indented passage. The court concluded that the essence of the concept was to be found in violence or threatened violence. So that's the first of the three requirements. The second, very important precondition to the use of the power is that the breach of the peace must be imminent. And that requirement was discussed and explained in great detail by their lordships, in particular in the speech of Lord Roger. If my lords turn to paragraph 62, where Lord Roger says, for the most part, the common law is concerned to punish those who have committed an offence, to deter them and others from doing so in the future. It doesn't step in beforehand to prevent people from committing offences. The duty to prevent a breach of the peace is therefore exceptional. If not kept within proper bounds, it could be a recipe for officious and unjustified intervention. The common law guards against this danger by insisting that the duty only arises when the police officer apprehends that a breach of the peace is imminent or about to take place or about to be committed or will take place in the immediate future. And then last sentence at the top of the next page, if he, that's the officer, reasonably apprehends that a breach is likely to occur in the near future, his duty is to take reasonable steps to prevent it. And then just picking that up at paragraph 69, this doesn't mean, says Lord Roger, that the officer must be able to say that the breach is going to happen in the next few seconds or minutes. That would be an impossible standard to meet, since a police officer will rarely be able to predict just when violence will break out. The protagonists may take longer than expected to resort to violence, or it may flare up remarkably quickly. Then skipping over the next sentence, there is no need for the police officer to wait until the opposing group hoves into sight before taking action. That would be to turn every intervention into an exercise in crisis management. There's then a reference to the New Zealand case of Minto, then the Strasbourg case in Steele, and I'll go to Steele shortly, but just picking it up above letter G, in neither case could the police officers have predicted exactly when the violent reaction provoked by the protests would occur, but I have no doubt they were entitled to take preventive action on the view that it was likely that a breach would occur sometime in the near future if the protesters persisted. The European Court held that arresting the protesters to prevent a violent reaction had been justified and there was no breach of Article 5.1. So, first protection is violence, second protection is imminence, third protection is that the power can only be used when it is necessary as a last resort, or to put another way, where its use is proportionate. And my Lord Mance spelled that out in paragraph 141, MS 1405, I beg your pardon, MS 1404, letter H. my Lord Mance said, by letter H, where a reasonable apprehension of an imminent breach of the peace exists, then the preventative action taken must be reasonable or proportionate. And then at letter B on the facing page, the requirement of imminence is relatively clear-cut and appropriately identifies the common law power or duty of any citizen, including the police, to take preventive action as a power of last resort, catering for situations about to descend into violence. And then Lord Brown, very briefly at paragraph 114, just for my Lord's note, says much the same thing. My Lords, coupled with those requirements, there are two other important requirements concerning the permissible duration of a person's detention. They were summarised by my Lord Justice Dyson, as you then were in Williamson, Volume 1, Tab 3. The issue in Williamson before the Court of Appeal was whether breach of the peace was an offence within the meaning of pace, so that the provisions of that act applied where a person was arrested and detained for breach of the peace, as explained by my Lord in paragraph 6. But can we look straight at paragraphs 19 to 21, MS 1420? Second sentence of paragraph 19 starts by letter H. The common law provides persons arrested and detained for breach of the peace with a considerable measure of protection against arbitrary arrest and or unreasonable detention. Arrest may only be lawfully made if the breach of the peace is being or reasonably appears to be about to be committed in the presence of the arresting person. We've seen that from Laporte. When a person is arrested at common law for breach, the arrested person must be taken to a police station and then brought before a justice as soon as reasonably practicable. So that's the first temporal protection. Then the second temporal protection can be found at paragraph 21. If the police consider, or reasonably to consider, that there is no longer a real as opposed to fanciful danger that if released, the detained person will commit or repeat his breach within a short time, and they decide or ought reasonably to decide that a bind-over is unnecessary, then continued detention is unlawful at common law. And then finally, as to the powers of the
What's the
magistrate...
point of bringing them before a justice as soon as reasonably practicable? Is that explained in Lewis and Timms?
That is for the justice to consider whether they ought to be bound over.
No, Lewis and Timms wasn't a bind-over case.
No, Lewis and Timms, John Lewis and Timms was not a bind-over case. Yes, but my Lord Dyson has taken from that, and I think uncontroversially so with respect, a temporal obligation to bring the person detained before the court as soon as possible, as soon as reasonably practicable.
But you say it's for the purpose of considering a bind-over.
Yes.
That, you say, is to be found in the Act.
Well, I'll consider my Lord Coulson's question as to what the source of that understanding is overnight, but I don't understand it to be controversial between the parties. Right. The best place to find what the powers and obligations of the magistrates' court are for present purposes are actually in the Commission's decision in Steele, Volume 2, Tab 13. MS 1821. Top of the page recites section 115 of the Act, the power of a magistrate's court on the complaint of any person to adjudge any other person to enter into a recognisance with or without sureties to keep the peace or to be of good behaviour towards the complainant shall be exercised by order on complaint, ... If any person ordered by a magistrate's court under subsection 1 above to enter into a recognisance with or without sureties to keep the peace or to be of good behaviour fails to comply with the order, the court may commit him to custody for a period not exceeding 6 months. And then the Strasbourg Commission of the Club and Court explains carefully what the procedure is. The procedure is begun by the laying of a complaint. Before the magistrates can make the order, they must be satisfied on a basis of admissible evidence that the defendant's conduct caused a breach of the peace or was likely to cause one. So the Strasbourg court plainly understood that this was a preventive power, And two, unless the order is made, there's a real risk that the defendant will cause a further breach of the peace.
It used to be a full treatment on the whole issues relating to Bindover, instead Justice Manual, but I'm speaking from rather distant recollection.
We will look.
I don't know if it still does.
We will look. And then paragraph 34 cites Lord Justice Simon Brown, as he then was in the Nicol Divisional Court decision, in a nutshell saying that even though no criminal conviction as a matter of...
Criminal standards, yeah.
Precisely. My Lord, can I now turn to the Strasbourg case law on Article 51C? And I'm just going to give my Lords a roadmap as to where I'm going to be going.
I hope you're not going to drive us over the hill.
It'll be a speedy and focused drive.
Roller coaster.
Yes. Yes. We're not going to be left dangling anywhere, hopefully. The starting point, as I think Miss Kaufman recognised and the Court of Appeal recognised and my Lords suggested this morning, is obviously the text of Article 51C itself. And on its face, that subparagraph allows the detention of a person for the purpose of bringing him before the competent legal authority when that detention is reasonably considered necessary to prevent him committing an offence, i.e. prospectively. My Lords, that plain reading of 51C was in fact expressly accepted by the Strasbourg court in the very case that is the cornerstone of Leonard Friend's arguments, namely Ostendorf. If you pick up volume 2, tab 11, paragraph 84 at MS 1777. You see the court saying this. The court notes that the government advocated a revision of the court's case law on the scope of 51C. It agrees with the government that the wording of the second alternative of 51C, insofar as it permits detention when it is reasonably considered necessary to prevent his committing an offence, would cover purely preventive police custody in order to avert imminent, specific, serious offences, which is here at issue. So that is the Strasbourg court accepting that on the language of 51C, that is what it means. That's the first part of my roadmap. The second...
Well, you do actually have to read the next paragraph.
Yes.
Oh, of course, I'm going to come... My Lord, of course, I'm going to come back... I'm going to come back to Ostendorf to explain the genesis, in fact, I'm going to do it very shortly, of where the mistake in Ostendorf came from. I will do that, and I will confront the fact that I'm inviting you to depart from Ostendorf as the Court of Appeal did. I'm not shying away from that.
Why are you inviting us? Because you say it's not clear where Strasbourg presently stands, or because the line of authority isn't long enough and distinguished enough, or what?
Because on our submission, it is difficult, if not impossible, to reconcile Ostendorf with lawless Steele and Nicol on the one hand, with Ostendorf, Schwabe and Jessis on the other. There's therefore no clear and constant line of jurisprudence.
So it's the mixed messages.
It's the mixed messages, real judicial decision to be made. We are squarely within the ambit of this court's discretion is the wrong word, my lords.
We should express ourselves in a way which might appeal to Strasbourg, you say, in your... Yes.
I'll develop that point in due course.
Well.
Anyway, just carrying on with my map. The court's judgment in Lawless, in our submission, clearly recognises the freestanding existence of the preventative second limb of 51C, and at the same time made clear that where the detained person was brought before a judge stroke competent legal authority under that provision, read with Article 5.3, it could be for the purpose of examining the question of deprivation of liberty or for the purpose of deciding on the merits. Either would be sufficient. That's Lawless, which we say is squarely in our favour.
And is there, what paragraph reference do you want?
14. It's the second half of 14 in Lawless. And I'll come back to all these cases, but I'm just foreshadowing what I'm going to say. The source of the difficulty in this case, we say, emanates from the court's later decision in Gessius, which on its face, I entirely accept, suggests that the person can only be detained under 5.1c on suspicion of his already having committed an offence. And with all the deference that is due to the Strasbourg court, we say that is clearly wrong for the reasons cogently explained by the Court of Appeal in this case, effectively because it collapses the second limb of 5.1c into the first. And I'd invite you in due course to read the part of the Court of Appeal's judgment where it grapples with this very issue.
Can you, at some point, you'll come to the point which has been interesting me and obviously was noted by the minority in Ostendorf, namely that why does it matter at all, really, which section you apply? Because if you bring this sort of situation within C, you're going to have precisely the same limits as you would have under B, so the whole question ought to be about what those limits are about.
Well, with respect, I agree with my lord that ultimately the question for this court is, was the detention in this case permissible under 5.1b or 5.1c? And there's no suggestion that these are mutually exclusive limbs.
No.
Detention can be lawful under both.
Well, on your case, yes, but the point, I think, being made by the minority in Ostendorf was that you would be unlikely to have a more relaxed regime under C than B or B than C.
Well, and Ms. Kaufman may say, well, there are different requirements entailed in both. And I don't go so far as to...
You'd have to go pretty far to get something out of the language, wouldn't you? I mean, you can make what you like of the language, words like reasonably and necessarily.
Well, absolutely, and proportionality affects the whole of the convention at some level.
Ultimately, I mean, this may all be completely academic, because the real point will be what are the conditions and were they applied on satisfied on the facts.
With respect, I would agree, and I'd also at the same time disagree with Ms. Kaufman, saying that if the Court of Appeal's approach is endorsed in some way, that will provide a passport to long-term executive internment.
Right.
The trouble is we've got to somehow grapple with the analysis, haven't we?
That's why I'm not going to shy away from it. We do say, with respect, that Gessius went wrong, and that what happens then is that the error in Gessius is repeated twice by the fifth section of the court in Schwabe and in Ostendorf, without any attempt by the majority to grapple with the inconsistency with Lawless that the minority expressly recognises. And so, with that body of case law in mind, including Steele and Nickel and Lawless on the one hand, and the erroneous Gessius followed in Schwabe and Ostendorf on the other, we say that this court, applying the guidance given by Lord Neuberger, in particular in Pinnock, and all the subsequent case law on Section 2 of the Human Rights Act, was correct not to follow Ostendorf. And then finally, as I've already submitted, even if the purpose of bringing somebody before the magistrates or before the competent legal authority under 5.1c is to conduct what Strasbourg would call a trial on the merits of a past criminal offence, we succeed anyway because that is precisely what a binding overhearing entails for the reasons I have given. Before turning to Lawless and then a case we haven't yet looked at, which is a Grand Chamber decision called McKay, can I briefly identify two overarching principles that affect, or in our submission should affect, the court's conclusion. The first is the well-known fair balance principle. I'm sure my lords have heard it many times before, but the principle is that inherent in the whole of the Convention, including Article 5, is the search for a fair balance between the demands of the general interest of the community, on the one hand, and the requirements of the protection of the individual's fundamental rights on the other. And that fair balance test has been set out and applied in cases ranging from those that are expressly qualified, like A1, P1, etc., all the way through to cases in what are sometimes called the first rank of fundamental rights, including Article 3. That's the fair balance principle. The second principle I'd rely upon is really an emanation of the first in the specific context of Article 5. And it is that Article 5, like the common law, cannot be interpreted so as to make it impracticable for the police to fulfill their duties of maintaining law and order and protecting the public, provided the individual is protected from arbitrary and unjustified detention. And, my lords, authority for all of that can be found in two linked decisions, both in the case of Austin, but first by the House of Lords, the second in the Grand Chamber. So just picking up volume 3 of the authorities bundle, starting with the House of Lords, tab 20, starting at paragraph 55 in Lord Neuberger's speech, we see at MS 1966 letter E, there's a reference to the fair balance principle, referring back to the seminal Söring case in the context of Article 3, and you see by letter F, inherent in the whole of the Convention, etc., etc. Then we see Lord Hope, in an important passage in the context of this case, at MS 1961, Lord Hope, paragraph 34, he says, I would hold, therefore, that there is room, even in the case of fundamental rights, as to whose application no restriction or limitation is permitted by the Convention, for a pragmatic approach to be taken which takes full account of all the circumstances. And then skipping over the next 4 lines, but the importance that must be attached in the context of Article 5 to measures taken in the interest of public safety is indicated by Article 2, as the lives of persons affected by mob violence may be at risk if measures of crowd control can't be adopted by the police. This is a situation where a search for a fair balance is necessary if these competing fundamental rights are to be reconciled with each other. And then turning to the Grand Chamber in Strasbourg.
You get the proportionality bit and arbitrariness at letter F.
Yes. Indeed. And then the Grand Chamber, volume 4, tab 42, starting at MS 2225, paragraph 56, middle of the page, as the court has previously stated, the police must be afforded a degree of discretion in taking operational decisions. Such decisions are almost always complicated, and the police who have access to information and intelligence not available to the general public will usually be in the best position to make them. So Ms. Kaufman says, well, the Starbucks claimants were just sitting in Starbucks having a coffee, but they were dressed in a particular way which intelligence available to the police indicated that they may be going on, as was feared, to the royal wedding procession to provoke a breach of the peace, including potentially by throwing maggots at the celebrants. And then at the bottom of paragraph 56, last sentence, Article 5 can't be interpreted in such a way as to make it impracticable for the police to fulfill their duties of maintaining order and protecting the public, provided that they comply with the underlying principle, which is to protect the individual from arbitrariness. So those are important overarching principles which we say are relevant, obviously, in the context of this case. Can I then go back in history, as it were, and deal briefly with the Lawless and Ireland case, volume 1, tab 8, No, that can't be right. Volume 2, tab 8. MS 1688. All I want to say about that, because my Lord has seen the passage already, is that at the bottom of page 1688, in the last 4 lines, in particular the last 2 lines, it is clear that the Strasbourg court contemplated that Article 5.1c, read with Article 5.3, entails an obligation to bring everyone arrested or detained in any of the circumstances contemplated in 5.1c before a judge for the purpose of examining the question of deprivation of liberty, or for the purpose of deciding on the merits. Not both, as Miss Kaufman says. Miss Kaufman effectively...
we have got these points. I mean,
My Lord,
we
yes.
went through them.
Can I then take you to McKay, volume 6, tab 57. This is a Grand Chamber decision which concerned primarily Article 5.3. The facts were that somebody was arrested for robbery, admitted the offence of robbery, and is then charged. And the question directly before the Grand Chamber was whether 5.3 required that the magistrate before whom Mr. McKay first appeared itself had to have the power to grant bail, or whether it was sufficient for that power to be capable of being exercised on application to the High Court. If my Lords turn, please, to MS 2817 and pick it up at paragraph 31. Article 5.3, as part of the framework of Article 5, is structurally concerned with 2 separate matters. The early stages following an arrest, when an individual is taken into the power of the authorities, and secondly, the period pending eventual trial before a criminal court, during which the suspect may be detained or released with or without conditions. These 2 limbs confer distinct rights and are not on their face logically or temporally linked. And then from paragraph 32 all the way through to paragraph 40, we are concerned with the first of those 2 limbs and what is entailed in that first limb. And picking it up after the reference to promptness and automatic nature of review, at paragraph 35, we see the judicial officer must offer the requisite guarantees of independence from the executive and the parties, and must have the power to order release after hearing the individual and reviewing the lawfulness of and justification for the arrest and detention. As regards the scope of that review, the formulation which has been at the basis of the court's long-established case law dates back to the early case of Schieser and Switzerland, which my Lord's note is at tab 60 of the bundle, where, picking it up in the fourth line of the indented passage, the substantive requirement imposes on him, that is the judicial officer, the obligations of reviewing the circumstances militating for or against detention, of deciding by reference to legal criteria whether there are reasons to justify detention, and of ordering release if there are no such reasons. More recently, this has been expressed by saying, in other words, Article 5.3 requires the judicial officer to consider the merits of the detention. And then that is then expanded upon at paragraph 36. And at the bottom of the page, there is nothing to suggest that when referring to the circumstances militating for or against the detention, the court was doing more than indicating that the judicial officer had to have the power to review the lawfulness of the arrest and detention under domestic law and its compliance with the requirements of 5.1c. So although I entirely accept that you have to read 5.1c together with 5.3, such a holistic reading does not, as Miss Kaufman submits, necessitate that there has to be, in every 5.1c case, a trial on the merits.
Sorry, and which particular sentence?
Well, it's the whole of the passage I've just taken my Lord to, which makes clear that 5.3 can entail looking at the legality of detention. And when we come to look at Austin Law, we say that is inconsistent with the court's reasoning.
Yeah, yeah.
The next case is Steele, where, as my lord will recall, both the Commission and the court, so this is at volume 2, tab 13, both held that the applicant's initial arrest and detention prior to being brought before the magistrate was lawful under Article 5.1c. The main argument in Steele was whether the law of breach of the peace in English law, and I recognise that my Lord Reid will know the law is somewhat different in Scotland, but the law in England was defined in a number of cases and was found to be sufficiently well defined to meet the requirements of lawfulness or specificity in Article 5. The Commission found that it was, and having so found, the Commission then goes on to find that the detention of the applicants had been lawful under 5.1c. If you turn, please, to it's page 61 of the report, which is MS 1830.
This is the Commission.
This is the Commission. Commission says, 104, MS 1830, under 5.1c, detention of a person is permitted if effective for the purpose of bringing him before the competent legal authority on reasonable suspicion of having committed an offence. That's the first limb of 5.1c. The applicants who are arrested to bring them before the magistrate on reasonable suspicion of having committed a breach of the peace. The Commission has found that proceedings for breach of the peace are proceedings which determine a criminal offence. In the same way, the Commission also considers the breach of the peace is an offence within the meaning of Article 5.1c, and then it therefore concludes that there's been no breach. So that's the Commission's reasoning. It's important to note that that finding is made even though on the facts, the initial finding, the initial detention until 11 p.m. had been expressly effected to prevent any further breach of the peace. If you go back to paragraph 9, you see MS 1816. She, the applicant, was taken to the police vehicle where she was detained until 3:15 p.m. At approximately 7:15, she's taken to the police station. Upon review, her continued detention was authorised to prevent any further breach of the peace, and then subsequently at 6:25 to place her before the court later that morning. Now, Ms. Kaufman might say, well, the detention to prevent any further breach of the peace was unlawful as a matter of 5.1c, but that is then addressed by the court's judgment. We see the court's judgment, and can we pick it up at paragraph 48, beg your pardon, 46 at MS 1844, where the court said, not disputed that the breach of the peace was a criminal offence and that the applicant's arrest before being brought to the magistrate's court fell within 5.1c. Then paragraph 47, the court recalls that each applicant was arrested for acting in a manner which allegedly caused or was likely to cause a breach of the peace, so preventatively, and detained until he could be brought before a magistrate's court. Breach of the peace not classified as a criminal offence under English law, but the court observes that the duty to keep peace is in the nature of the public duty. The police have powers to arrest anyone who has breached the peace or whom they reasonably fear will breach the peace, so they well appreciate the preventative nature of the power, and the magistrates may commit to prison anyone who refuses to be bound over, where there is evidence beyond reasonable doubt that his or her conduct caused or was likely to cause a breach. Bearing in mind the nature of the proceedings in question and the penalty, the court considers that the breach must be regarded as an offence. The court therefore finds that each applicant was arrested and detained with the purpose of bringing him or her before a competent legal authority on suspicion of having committed an offence, that's limb 1, or because it was considered necessary to prevent the commission of an offence, that's limb 2. There could not be a clearer statement recognising certainly in the English context, that the preventative power to detain somebody for breach of the peace is entirely compatible with 5.1c. And I'm not going to go through all the passages now, but there are several other passages, including paragraphs 55, 57, 60, and following, where the court makes clear that it well understood the preventive nature of the breach of the peace power. I'm not going to spend... Well, I can see it's 4 o'clock. So,
How are you doing in terms of time? Because you started a quarter of an hour late.
Yes, I started at 3. I've had an hour.
Do you indented for 2 hours, 45 minutes?
I won't need another hour and 3/4 tomorrow.
Right, so
I'll be as quick as I can.
we don't need to sit any extra time.
I'm up to page 10 of my... I do myself notes, and it's normally a good indication. I'm up to page 10 of my notes, and I have 12 more pages to go.
Right, so we will resume then at 10:30. Thank you very much indeed.